Did you do that?
No.
Chair. What? I got here.
Take care of my system.
Yeah,
Me too.
I got my first text from Otto at 5:45. I was like, that noise. That's okay.
That's just my bad understanding of Ohio geography. It's my. What time should we?
Yeah.
Get on.
No, I was.
Yeah. It's kind of like.
And then I looked on my email and then I printed it out. Yeah.
How long did it take you to get? Just about 2 hours. It was like 2:15.
Sure.
Stop and share.
There you go.
There's a rule where if you go by someplace like that, you have to bring it up to the whole class.
Oh. Next. Now that I know that there's expectations.
It's one of those unwritten rules.
You probably pick it up and I'll walk away. I can get it here.
This was hilarious.
Oh, then you-
Not too bad, that's-
So,
Anytime you're ready.
Moving that away. I don't know how it's gonna happen.
I don't either.
no.
Noxious.
Oh,
Okay.
thank you.
Don't have it in them to communicate that way and then show up as a press conference.
Okay, ready? At this time, it's 10:02. I would like to call what is today? February 23rd, 2023, meeting of the Ohio Elections Commission to order. Mr. Executive Director, will you please call the roll?
So, Mr. Lyle. Here. Mr. Beatty. Here. Ms. Hagan.
Present.
Mr. Knight.
Here.
Mr. Kreitz.
Present.
Vice Chair Tavares.
Here.
Chair Kaufman.
Here.
All members are present.
I think you'll have to have that mask.
At this time, we would like to have approval of the meeting minutes from January 26th, 2023.
Second.
All right. There's been a motion on the floor that has been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with the vote of 7-0.
Take word of check first and go through, because it shouldn't take.
So at this time, we're gonna kind of go out of order. We're gonna go to the $50 fine category. We have someone present, Paul Marnichek.
It's item number 30, case number 2022 R601. This is a referral from the Cuyahoga County Board of Elections. We just as a figure file a complete and accurate statement. Mr. Martichek used cash at a fundraiser to pay for certain services at that time. That leads to a problem with case finance filings, which is why the board referred him. I synopsized his response, which was submitted. All reports have been filed. He's good in that regard. My recommendation is to find a violation of close to $50. Certainly, we can hear further from Mr. Martichek, and the commission can do as it wishes.
Would you like to make a statement? You'll have to be sworn.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
So I'm Paul Martichek, give you my address.
Do we need that?
Not necessarily, I mean, we have it, you're welcome to
Different
provide
procedures
it, right?
So Chairman Kaufman and commission members, my name is Paul Martichek. I think you all have my materials. I think it was a pretty easy mistake. What I did was I had a campaign fundraiser that was a cookout, and I had an individual come and cook the hamburgers, hot dogs, and I used funds that were raised at the event, cash, to pay the individual. I reported the donations, I reported the expense. The Cuyahoga County Board of Elections has done a great job explaining to me that the mistake I made was the funds never hit my bank account. I understand the error, I understand why that is the rule. Now that I'm aware of it, I think it's very unlikely I would ever make such a mistake again. It was just, I mean, simply put, I wanted to give the individual their money versus having to, okay, find you tomorrow, get you a check. I just wanted to, kind of button everything up. So again, I do apologize for taking up your time. Executive Director, as he mentioned, he did recommend a $50 fine. I'm hoping maybe the commission would see fit to just give me a warning, given that it was an isolated incident. And again, all funds were reported. It was just, I made the mistake of never putting them into my bank account, my campaign account, and then writing a check. And I'm happy to answer any questions or elaborate if you want.
Commissioners, any questions?
Chair Kaufman, to the director, is this a first time offense?
There was a prior in 2013.
I can elaborate on that. Like,
The league filing on the annual report.
Yeah, that, but we good call, that was, there it is. That was good caused in 2013.
So what I had done was I filed the campaign finance report. I didn't realize the deadline was 4 o'clock instead of 4:30, and I think I filed it at 4:08. So I was off by a few minutes, but again, it was 2013.
Are you currently in office right now?
I am. I'm currently in my first term as president of North Royalton City Council, after serving 10 years as the Ward 4 member of City Council.
Any other questions from commissioners?
No.
Mr. Director, do you have any other comments?
The reasoning behind the $50 fine as opposed to good cause is because of the 2013 prior?
No, it's because of the circumstances as I interpreted what occurred. That's my interpretation of, there should have been a payment reflected properly in the campaign finance report. With money coming in, check going out, appreciate that can be a pain, but that way you properly processed and reflected all of your expenses. That's the reason why.
I mean, that he, didn't know and was kind of a rather simple, I'd call kind of common sense transaction, and feels like an honest mistake. It doesn't kind of change your perspective at all.
It does, I was gonna say, it doesn't change mine, but you're certainly welcome to treat it in that manner, and I would encourage you to do so. If that's, if that's the understanding that you have and you want to take, I don't have any problems with that.
Mr. Richter, you've been in your position for a long time, and I'm sure you're familiar with the types of training that candidates receive through, parties, through boards of elections and everything like that. Would you describe that type of, I don't say rule per se, is kind of a one-on-one type thing that is told to candidates, particularly with the importance of having the bank account?
Campaign finance basics is probably a fair way of putting it. I would say, yes, it's one of those things that, it can be kind of a pain. We have a couple of other cases where that was key. I think 2022 R602, and I think there was another one as well where I appreciate the convenience and wanting to do it that way. I'm not unsympathetic toward that, but as campaign finance law, I want you to put the money into your account, pay the money out of your account. And so, that's at least the basis for my recommendation.
Right, because it would be convenient to have somebody sign over a check or write the check directly to as well.
Well, we had a case like that where you're talking about with the.
That was a very short day.
It wasn't that long ago, the problems that caused, so. I with some of that, I'm reminded at the various times of dealing with the state on payment. Very early on, when the state implemented the new system, it's been now for a while, we were told, people realize that the system is there not for ease of use, but for accountability. It's like, we've always, Betty and I, over the years, always kind of used that as a bit of something pejorative, but that was what we were told, not for ease of use, but for him. And I think to a degree, you could say that's here.
Chair Compton, ask question, Director Richter. Was this quickly resolved? It looks like all contributions and expenses are properly reflected in the campaign finance report. So once they were made aware of this, was this something that was taken care of quickly?
Yes, my understanding from the board is that, yes,
Yeah.
it was not that, timing was not an issue as it relates here.
So for the chair, to the commissioner, it was properly included in my 2021 annual campaign finance report. And it came to light when they were doing the audit and noticed that the amount I had deposited did not reflect what I had raised, and it was ultimately determined it was the $100. That was, so all my reports were in on time. Yes.
Madam Chair, I'd make a motion that we find a violation for good cause.
And impose a fine or
No fine. No fine.
Second.
We have a motion on the floor that's been duly seconded. All in favor, please signify by saying aye.
Aye.
Opposed, same sign. So let us reflect that the motion passes with a vote of 6-1.
No, 7-0. Oh, did you?
No, it's one.
Oh, you did. Okay, I'm
You
sorry.
didn't get a window to fight us.
I'm sorry.
Thank you.
Madam Chair,
Yes.
just since we are on video, just to forget to reflect that my reaction to the Advantage story was based on my software background and the comment around ease of use having not, and was in no relation to the case.
So there's no fine and you are free to go. Thank you for appearing today.
Thank you for your time.
Yes. Okay. So we're gonna go,
I'd recommend going through the things here, because it shouldn't take us that long to go through since I don't believe anybody else is here for matters aside from the Blystone case.
okay.
And so that way we can get this all done, then just have that to do with at the end.
Nobody on.
And that also gives Mr. Ramsey, I don't see Mr. Ramsey around, a few more minutes, maybe he comes.
So at this time, we're going to go through the group recommendations. The first recommendation is category is no violation. That would be case number 2022R-604. Mr. Richter.
Yeah. Members, this is a referral from Portage County for a late filing. A report was filed a day late. But when the treasurer for the Davisville Responsible Retail submitted his response and was in contact with me, what he had done was he contracted with, I think it was FedEx, I think it was UPS, FedEx Overnight in order to deliver the report on a timely basis. But the report, instead of being delivered to Portage County, was delivered to a different county. I don't remember which one. You have to look at the response. And so by the time they realized that, they got to the office the next day. Back in 96 or 97, I think it was, we kind of established a standard at that time in a case involving then Governor Voinovich that had the same thing occur through him, where, they had to file their annual report with the Secretary of State's office and UP or FedEx didn't deliver it timely as they agreed to. So we said, okay, if you enter into an agreement like that, not just stick it in the mail, but some overnight or guaranteed 1 day, 2 day delivery, that we will find that there's no violation when the contractor does not live up to their responsibilities. That's the case here. Yep.
Okay. So hearing Mr. Richter's explanation, do we have a motion?
I'll second.
Okay, so we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.
Or do you have questions?
I was just wondering if it was originally addressed to the appropriate location.
It was, he showed you that.
Okay, so any opposed? Same sign? Okay, motion passes 7-0. All right, the next category is the good cause category. Do you want me to submit them as a group?
Yeah, may as well.
Okay. These are cases 2022R-559, 2022R-576, 2022R-577, 2022R-588, and 2022R-599. Mr. Richter?
The outlier here I'll deal with in a second, but case numbers 576, 77, 88, and 99 are all circumstances where the report was filed, but it was filed within a week or 10 days of the due date for filing. A response was submitted that explained the facts and circumstances. Case number 2022R-559 was actually on the last agenda on January 26th, and I continued it from that meeting. And then on, I think it was either that day or the next day, I got an actual response from the respondent that had been delivered, speaking of missed deliveries, it had been delivered to the Ethics Commission, even though it said that it was sent to, I think she did have the Ethics Commission written on there, but it gave our address, 77 South High Street, Suite 1850. So somehow the mailroom sent it to the Ethics Commission. Anyway, it came back to me. And in looking, if you look at the ICW, there are a couple of priors, and one of them was decided, I think, in October, was imposed $100 fine. And that has not yet been paid, but we only got notice out right just before the January 26th meeting. So I'm kind of looking at this as something of an equity situation where she did try to get a response into us and had our address on it. Unfortunately, the state delivered it to the wrong, or somebody delivered it to the wrong address. And so that's the basis for, in that case, my recommendation for the cause, and you heard my recommendation on the other ones.
Any questions from commissioners? Hearing none, do we have a motion?
Second.
We have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Post same sign. Motion carried.
Wait.
It's a one.
Okay, the next group for consideration is consolidate all matters, find a violation, but find good cause. Those cases are 2022R-589, 2022R-591, 2022R-592, and 2022R-600. Mr. Richter.
Yeah, the reason for the consolidation here is this is a joint, I think it was a Board of Education campaign committee. I think the candidate and treasurer was Woodrow Marcus, case number 600. He was a couple of days late in filing the campaign finance report. We received individual referrals for all 4 candidates, but it's involved with one committee. So that's why I'm recommending that we consolidate all these matters into one. And considering that it was only a few days late, my recommendation is to find a violation, but for good cause, not impose a fine or for the prosecution. I'm going to answer any other questions that you may have.
Any questions? Okay, hearing none, do I have a motion?
So moved.
Second.
We have a motion that has been duly seconded. All in favor signify by saying aye.
Aye.
Post same sign. Motion passes 7-0. Okay, the next category is a $50 fine category. That would be cases 2022R-582, 2022R-584, 2022R-590, and 2022R-598. Mr. Richter.
Madam Chair, there was a question. First, I'd like to remove item number 27, case number 2022R-598. Was brought to my attention this morning that Bill didn't have a very good recommendation there by Mr. Weil. I appreciate that. And so I'll deal with the other 3 matters first. Reports, I believe, in all 3 cases have been filed. Still check real quick. Well, no, that's stupid, Phil. I don't make that recommendation unless they're filed. Of course, the reports were filed, but they were beyond the, a period of time close to the due date for filing. Mr. Corrigan was just filed in mid-January. Max was filed in mid-December when it was due in May. Committee for Excellent Schools was filed in February, when it was February 2023, when it was to January of 22. And so this is the first time. Well, I think I took also into consideration, looking at 582, I took into consideration the treasurer's circumstance as it relates to what went on there. But anyway, my recommendation on those three matters is to find a violation and impose a fine of $50. I'll talk about 2022 R598 here in a second. You deal with 582, 584, and 590. I'll be glad to answer any of the questions you may have.
Any questions?
Move we follow the recommendation of the executive director.
Second.
We have a motion that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. The motion carries with a vote of 7-0.
As it relates to 2022 R598, Mr. Lyle, asked about the somewhat inconsistency of a $50 fine recommendation here with priors. And then when I look back at it again, not only that, but I should have recommended that it be consolidated. And so, we certainly received a response. Oh, no, I see why I did $50 on that. I'll add a little more, and see if Mr. Lyle goes along with my recommendation as I look at my recommend, as I recall the explanation given to me now, that the candidate inappropriately linked personal business campaign PayPal accounts led to a mistake in campaign finance, but additionally, this was somebody else. Never mind. Here's my recommendation on 2022 R598. I thought I was misreading something, or I was misreading a different circumstance that I recalled from somebody who had security issues with an account. That's not the case here. Anyway, my recommendation as it relates to 2022 R598 is to consolidate it with case number 2020 R479 to find a violation and impose a fine of $100. I'll be glad to try to answer any other questions you may have based on the blurbs that I just threw out there.
Okay. Any questions for Mr. Richter? Okay. Hearing none, do we have a motion?
Move that we follow the recommendation of the executive director.
Second.
Second.
So we have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0.
No, let's go through.
Okay.
Then we can just do the consideration.
Okay, perfect. Okay, so the next category is the $100 fine category. Those are cases 2022R-583, 2022R-594, and 2022R-602. Mr. Richter.
In case number 2022 R583, the report was filed. It was about 6 months late, so no response has been submitted. As it relates to case numbers 594 and 602, reports have been filed. They were differing times of lateness. September, or I think Mr. Ruckers was December. Was that right? As I recall? Oh, no, they were both
This was February. Rucker,
Rucker.
report 211-4. It was
Yeah,
filed
September, and the other was in January. They were due around November for addendum. Those two have priors. The first item, the laborers local 534, there's no priors, but there was no response submitted, giving me an understanding of why the report was not timely filed. And so my recommendation on these three matters is to find a violation and impose a fine of $100.
Any questions? And then do we have a motion?
So moved.
second.
Okay, we have a motion on the floor that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. Okay, the next case is a $300 fine category. That would be case number 2022R-587. Mr. Richter.
This is a case where the reports were filed. They were filed in December, although they were due in November. I had very lengthy conversation yesterday with Mr. Kraus. He was not happy with my recommendation. He then called back to the board. I talked to the board staff and certainly wasn't encouraged to either allow the withdrawal of this referral or change my recommendation. So considering the number of prior violations that this candidate has had over the last few years, very recent years, my recommendation is to find a violation and impose a fine of $300.
Chair Conklin, Director, how many violations have you had previously?
I think it's 4. And the last time he was before the commission, and she pointed out to me as we had our discussion yesterday, was, well, they said it was okay the last time. That's also not you, because you were on the commission at that time. But my recollection was I could go back and look at my recommendation sheet, but I think I recommended the fine there, but he came down, appeared before the commission, gave an explanation. The commission was moved by his explanation, found the violation, but for good cause. But you go back to 2019, we had a violation imposed a $200 fine. You go back to 2016, you had a violation imposed a $100 fine. I go back to 2014, had a violation imposed a $50 fine. Back to 95, actually, you had a $100 fine. And so, you know, and in this particular set of circumstances, what he did was his bank was charging him fees on his account. So he took his money out of his account, more or less put it under his bedpillows and didn't put it back in an account. And the board didn't like that. So it finally put it back into an account that wasn't going to charge him any interest. But by the time he did that, it was already been like 11 months or 12 months, I think, in terms of how long he had it out where there was no accounting of the monies. And so the board has indicated they don't want to withdraw the referral based on this history. My recommendation, again, is to find a violation, impose a fine of $300.
Any other questions?
I'll
Hearing none.
move the recommendation of the executive director.
Second.
Okay, so we have a motion that's been duly seconded. All in favor signify by saying aye.
Aye.
Opposed, same sign. Motion carries with a vote of 7-0. Okay, the next category is a $25 a day with reconsideration option with payment of $250. That would be case number 2022 R-80.
And I will speak not only to this case, but to the next 3 subsequent items on the list where they are all recommendations for me to find a violation, impose some sort of a per diem sanction because reports have not been filed. That's the case here. Mr. Schuster has had a previous case before the commission when the report was not filed. He's back again. The reports still have not been filed. Yeah, he was in Butler County. Butler said, no, he hasn't filed anything yet. Hasn't filed anything since 2020 for I think it was, he filed in 2020 for like a 2017 annual or something like that. He hasn't filed anything since. So this case is the one involving Mr. King, items 3 and 32, where obviously the amounts are higher. The differing amounts are just because they have more prior times when they've been before the commission. And the reports have not yet been filed. And so, you know, my recommendations all deal with the fact that, you know, if they get around to making the filings and file their reports, we can reconsider the matters, but the board all indicated that the reports of these matters have not been filed. Yeah.
Okay.
Whether
So that would also be case number 2022 R-596, which is consolidated with case number 2021 R-470. Find a violation and impose a fine of $25 a day with reconsider option with payment of $250. And then cases 2022 R-574 and 2022 R-603, which is a $9,675 fine plus $25 a day with reconsideration option. So those are the cases that we are voting on at this point.
the 2 down years.
Oh, I'm sorry.
Those
And
are-
then also 2022 R-575, 2022 R-581. Those are 38,800 plus $100 a day with reconsideration option. So those are the block of cases that we.
Just as a side note, that 38.8 reflects $100 per day from the 2022 filing date until today's meeting.
So do we have a motion?
I move we follow the series of recommendations of the executive director in these cases.
Chairman Coffin, may I ask a question?
Sure.
In regards to the last 4 cases, you said all since their filing due date in 2022, is that right?
Correct, for annuals.
Have they made any effort or given any attention to the matter whatsoever at all?
Not, what I will do is when we get a situation like this, I'll reach back to the board, show them what my, I send them a copy of my ICW that you get, and say, you know, let me know if they filed. And in some regards, I will get just responses back and say, no, nothing's been done. Generally speaking, from Cuyahoga, I get a more in-depth response from Rosemary Amato. And, you know, she encourages strong fines, and she's indicated that no reports have been filed, and that is the case today. I know that's the case for Citizens for Change. I don't think Drew Davis was tied with the case.
As a Butler case.
City Butler County just said no, that they had not received any reports from, when I reached out to Butler, because initially the laborers level, item number 12 up above, was a failure file when it was originally submitted. When I reached out to Butler, they said, no, they filed in July. And they said, no, nobody else has filed with us, so.
And on the Davis case, I just add, they did receive it on 12/23. Return receipt. They've been notified.
Thank you. I didn't mean to start the motion.
So we have a motion that's been made. Do we have a second?
Second.
Okay. So a motion on the floor that has been duly seconded. All in favor, please signify by saying aye.
Aye.
Aye. Opposed, same sign. Motion carries with a vote of 7-0. Okay, the next group are continued upon request of respondent.
Yep.
So that would be 2022 R-552, 2022 R-585, and 2022 R-593. The next group would be continued for service. That would be 2022 R-578, 2022 R-579, 2022 R-586, 2022 R-595, and 2022 R-597. Those are all continued.
Correct. Correct.
Okay.
And you have now continued those, Madam Chair.
So the next item on the agenda is a reconsideration. That would be 2022 R-395 and 2021 R-419, and we have representatives here. So,
Correct. Madam Chair, members of the commission, these cases were decided by the commission in October, where after a number of years, a series of cases being outstanding and reports not being filed, the commission was informed by the treasurer and also by the Cuyahoga County Board Office that the reports had all been filed and that the campaign committee was in compliance, having brought all their outstanding problems into compliance, and so that the case was ready for resolution. Ken Ramser had come in as treasurer for the JECA campaign and made sure all those filings were made, filed a response. You can see the synopsis of it that I have here included in the reconsideration worksheet that I sent to you a couple of years ago. Much work, the new treasurer worked with staff of the board, submitted all the outstanding items to the committee in compliance. My recommendation at the time was to find a violation and impose a fine of $2,000. As much or more than anything because of the number of outstanding cases that the commission has had over the years. The fact that there was a 2011 case that was never brought into compliance at that time, and no reconsideration was made initially, and subsequently there was, and we imposed a $100 fine in 2014. Then all subsequent cases occurred again. So my recommendation, after consolidating all the outstanding cases, was to find a violation and impose a fine of $2,000. Mr. Wamser reached out to me last week, the week before, expressing his discontent, shall I say, with the amount of the fine that I recommended, and that commission opposed. I indicated to him that I would give him an opportunity to come down and address you individually, if he was so inclined, to give further explanation, that may, may make the $2,000 fine seem overly burdensome. It certainly could be. I understand when people like it when they're fined. But I indicated to him I would not be recommending a change to my recommendation. But if he wanted to address the commission, and give an explanation, that maybe you would, be kinder, and change the finding and impose a lesser. So,
Morning, my name is Ken Ramser. I'm a treasurer of White Jets.
you'll need to be sworn by.
Oh, I'm sorry.
No, you're fine. That's fine. If you want to.
Yes, I do. Morning. My name is Ken Ramser. I'd like to thank the commission for allowing me to come down here and present this appeal to you, and also the Board of Elections in Cuyahoga County for their efforts and time involved in this. Just to let you know who I am, what I do, or what I've done. I'm a 30-year Teamster. It's 11 years, 15 years elected official, 11 years Secretary Treasurer of Team Local 24. I was 2.5-year councilman, and 11-year clerk of council. I also served as was the Italian American Club. So what I'm trying to say is I've been a numbers guy for quite a while, and I know numbers, and I know how to figure things out. And, we did have a mess, but we were able to comply with everything that the Board of Elections is. Yeah, so you're like, how did we get here? Well, I'm going to tell you how we got here. Is I filed a report that I'm sure you know everything about filing reports to the Board of Elections. Is that you can't ask for an extension. You have to file a report in a timely frame, which I did. But again, I didn't have the numbers. So when I filed the report, it had to be on October 21st at 4 o'clock. I filed this on October 21st at 3:58. So I was racing against the time. And all I had in here was, and this is what really upset the board. And I get it. I really get it. Is I wrote in all the, where the money shows that amended report will show the amounts. So understand that I filed the report in a timely manner. But the amended report had all the numbers, which I did file. Bottom line is here, I have a lot of handouts, I have a lot of emails, and I don't know if you want to see them, but Mr. Ricker will verify with Roseberry model at the Board of Elections. We have satisfied everything that the board has requested. I committed to close this account out. Mr. Jack has no more political aspirations. In his, in Rosemary's one email, listen, I know the Jack fan. Mo was his treasurer. Mo was fighting cancer. So that's why I took over this thing, because Mo just couldn't handle it no more. And I took it on. And I got a packet from the Board of Elections that was pretty thick. And for me to figure it all out, it took a lot of time. But I was able to do it. I was able to satisfy all the board's requests. And I have the emails to show that all the way up until yesterday. And we're asking that this fine be rescinded. Mr. Jack is retired. He's living on his retirement. We closed the account out. It loaned himself $17,000 over a 22-year period. Okay. He wound up with $908 paid back to him out of his account when I closed that account. The check went to him. Mo was still fighting cancer. I'm down here and I'm not using that as an excuse, please. It's the truth. It's just the truth. And that's what I want you to know. That is why Mo had screwed up these reports. But we brought them all into compliance. I think that's the bottom line. And Mr. Ricker, again, I thank you for letting me come down here and appeal this case. So with that, I throw myself upon the mercy of this committee, and now rest of the way.
Anyone have any questions?
Chair Kaufman to the director, what was the time frame in which they were brought into compliance after the report was submitted?
Well, you know, as you look at the one ICW, the first referral was in 2019.
Michael, pass these out.
For the 2019 primary report, you know, at various times I would bring these back before the commission, request be made to continue it to give more time, which I granted. And so, you know, there were various things outstanding for, you know, by the time he brought it back to compliance, which was last August or September, I think, would have been in the neighborhood of 3.5 years, somewhere around there. And I, you know, I'll be honest with you, I was glad to see when the last continuance that I granted on these matters requested by Mr. Ramser, probably about a year ago at this time, when he indicated that he was getting involved, that he was going to bring them into compliance, and he asked for additional time. I said, that's fine, and I was honestly glad to see it, because nothing had been done for a number of years prior, obviously. And so, you know, I think he certainly lived up to what he said he was going to do, brought them into compliance and was able to get all. And so in that regard, you know, obviously, I guess I'd say that's a good thing. And his efforts should be lauded to be able to bring financial reports into compliance after so many years, because how many times have we dealt with things where we're declaring a committee either in compliance or terminated because they can't, but he was able to do it and bring it into compliance. So in that regard, I have to compliment Mr. Ramser for his efforts to bring the committee into compliance and work with the board to get it all done. So around 3 years or so is when we received the first referral. You know, how much led prior to that from the board, I can't say, but that's what we reflect here in 2019, our 439. I mean, for this, I think we just took them. But, you know, which deals get done.
If I could, the pass outs that I have here, this was the last one Rosa resent, said, if you see where it says, Roy, and you need to understand this is not a one-time fine. I understand that. His record of referrals are rather extensive the past few years. I'm telling you, Mo, when you're fighting cancer, you know, there's not a lot of things on your mind other than filing campaign finance reports. She filed them, but they're incorrect. It was things that she left out. She omitted who she wrote the check to. The amounts were wrong. And again, Roy, he's a candidate, but he's also fighting cancer too with his wife. So I'm not using that as an excuse. I'm using it as the truth. And if you see the next emails, these are the ones that I indicated I was coming down here. And if you see, my highlighter went crazy. It says that all of his reports, all of his check things are complete, compliance. I committed to Mr. Richter. I committed to the Board of Elections that I would straighten this out, comply with everything, and get this account closed. We're dinosaurs, me, Roy, and Mo. When the Board of Elections was able to get bank statements, it was all something new. Mo didn't realize that they were ready to do it. I even questioned it because when I was a councilman and I filed my campaign finally, of course, it was out required. So when I became clerk of council, I took on 2 campaign finance reports. One, Mr. Richter might recognize this name, was Debbie Lyme. It took a little while, but I got Lyme to the dime, and I completed that one. Then I took on Roy Jets because I seen they were struggling. It was more of a task, but I took it on and I completed it. And the reason I told you about myself is because I'm a numbers guy. It's basic math. You gotta know where you add and subtract. And all I know is a $2,000 fine, the first fine that I know of that was imposed upon Mr. Jack, and I think it's a lot of money for closes account. And the thing is, this hearing was in October, I believe, that you had this hearing. I was in Marco Island in Jan, for the month of January, and there was a letter waiting there from the findings from October. So we had no idea. We closed the account. We were waiting for a check for Mayor Tony B. Asada, Seven Hills. And that's why we waited so long to close the account out, because we're waiting for this check to clear. So I finally had to call Tony and tell him, hey, look, if you got that check, I got to close this account out. I had committed to do it. So if he has that check, he's out $50. So, but ladies and gentlemen, I did what I committed to do. And I'm throwing myself again upon the mercy of this committee to retract that $2,000 fine. And let us go out into the pasture, because I'm done. He's gonna retire from the city. He's done. The dinosaurs still walk the face of the earth. Okay? And
Thank you.
with that, I'll close unless you guys say.
Thank you. Do any commissioners have any questions?
I did just the executive director, Phil, based on the testimonies, and I don't know if you knew this, or were you aware of the health issues that were involved here?
I don't know that I was when I made my original recommendation at this point. Mr. Ramser mentioned that in our conversation prior to me saying, having him come back here at this point. I just didn't recall.
What was the highest actual fine that, and on the priors that was paid?
$100.
$100.
And that was when?
2014. Yeah,
Correct.
2014.
That's correct.
If I could be so bold as to say this, I have no knowledge of what you're looking at there, because it was pre-Ken Ramser. And I didn't have any knowledge of the priors other than what Ms. gave me there. But since I took over, this is Roy Jeck's finances right here. Pretty adamant in what I do. This is his, when I took over, this is it, finances, statements, everything. You're more than welcome to look through this. Being a Teamster, you said Board of Department of Labor looking at your the FBI and the thing called the Independent Review Board, along with the auditor. So I'm telling you, it's all here.
Thank you.
It's there for your viewing pleasure, like you look at.
Chairwoman, the recommendation to be to deny reconsideration, if we were to approve the reconsideration, would that mean the case would be again, or we could make?
Yes. If the commission was to bring the case back, what I would recommend the commission say is to reconsider the matter, vacate the previous imposition of the fine amount identified, and then state a different fine amount. Or find that there's good cause if that's what the commission wishes to do.
So we could jump to finding good cause or imposing a lesser fine.
Correct.
Yeah.
Correct.
Chairwoman Kaufman, sorry, I'm so used to that. I don't discount your eloquence. I appreciate it very much. But given the facts presented in the case, I would recommend that we impose a lesser fine and allow for them to move on with their lives.
You have a motion?
Say 500, 250.
It's up to you.
Against yourself.
If it's a bidding war, start at 20.
Okay. So,
Given that they're in full compliance and have made every effort to do so, it seems to me that it would be fair to consider a fine of 250.
So then, what it appears you want to do is to reconsider the matter, vacate the previous imposition of the $2,000 fine, and instead impose a fine of $250.
do we have a motion to that effect?
So moved.
Okay. Do we have a second?
Second.
Okay. We have a motion on the floor that's been,
Further discussion,
oh, do we have further discussion?
questions?
I agree with everything that was said, except I think the fine should be lower than $250. The reason I asked for what the prior fine was and when was specifically around having it be equivalent to that. So I would advocate $400 fine.
You wish to amend my motion?
Well, I can't. I'm just in discussion.
Okay. So do we have,
Yeah, no, no.
are you
So-
amending?
Is that a
I mean,
motion?
Christine asked the question. So are you amending the motion?
Well, I don't think I can. It's her
Sure you
motion,
can.
Yeah, you
right?
can.
Yeah, you can. You can. under-
Motion, you need a second, and then we vote on the amendment, and then
Oh, okay, fair enough. I would move to amend the motion by Commissioner Hagan to reconsider cases and find a violation and impose a fine of $100.
Second.
Any other discussion or questions? Thank you. Okay, hearing none. Oh, I'm still out.
No, I believe we have to vote on the.
Vote on the amendment.
the amendment
Amendment.
first, and then the
And then
amended
the
motion.
amended
The
motion.
amended motion.
Yeah.
Could I interject here or something?
No.
Wouldn't she?
At this point, I don't think so.
Okay.
Yeah.
I'm just saying, Robert's rules are always. All right,
Okay,
I better shut up.
okay, so
Some point.
the motion that we are voting on is to vacate Ms. Hagan's,
No, to amend.
To amend.
to amend
The
the
motion that we are currently addressing, I believe, is to amend Ms. Hagan's motion to reconsider the matter, vacate the previous imposition of the $2,000 fine with a $250 fine, but to amend that amount to $100.
So,
That's the current motion, is the amendment.
Okay,
So all,
I'm just-
all in favor, signify by saying aye.
Aye.
Opposed, same sign. Okay, that motion passes to 0.
now the motion that is
On the
before the
amended
commission,
motion, right?
the amended motion is to reconsider, vacate the previous fine amount, and instead impose a $100 fine.
That's, do we have a motion?
So moved.
Okay,
Second.
second, okay. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries 7-0. Y'all put me to the test right off the bat.
You did well.
Yeah.
They did my
Okay,
part.
thank you very much. We appreciate you
Thank you
hearing.
for your time and sorry for any confusion of what we might call it. Okay? Thank you so
Thank
much.
you for your time.
Mr. Executive Director.
Thank you,
would
Mr.
let
Director.
him- Would you let the gentleman know the next steps?
Well, we'll send out a notice that the commission accepted, that reconsidered the matter and imposed a lesser fine, and you'll get a notice from the commission about the lesser fine. So you don't need to worry about paying the fine that's currently sitting out there, because it's not out there anymore.
All right. Thank you so much. Thank you.
Thank you.
Safe travels.
Thank you.
Bye.
Have a nice Easter.
Thank you.
As you go.
That's what the human race should be all about. That's what the human race should be all about.
Okay. At this time, we are to the next group of reconsiderations.
Yeah, call them all together. Well, if you want me to, you got it. or you want me to?
No, yeah. We have Chambers versus Whitestone et al., 2021 G-022. Capella versus Whitestone et al., 2022 G-012. Capella v. Whitestone et al., 2022 G-013. And Ohio Secretary of State v. Whitestone et al., 2022 S-002.
Madam Chair, members of the commission, you're all familiar with what the commission accomplished on January 5th in terms of entering the agreement with the parties on matters and attempted to resolve these situations. As the payments were being made to complete that part of the agreement, you're all aware that the amount that were included in the agreement and were spoken to in comments to the commission were not met. Lesser amounts were received. And so I thought the most appropriate thing to do was to bring these matters back for the commission to reconsider it, because as you all recall, in the agreement, the commission maintained jurisdiction over the matter until it was fully resolved. So I think it's fair to say at this point it has not been fully resolved. And so it is back before us. And I think today, as much as anything, we should look at this as sort of an education session, shall we say, to try and ascertain what's going on, where the parties' respective positions are, and to use it as a manner of getting more information as to the current circumstances, what has occurred, why it occurred. And so, the case is now back before us. You've introduced it. We're here for reconsideration. We haven't exactly reconsidered it, but it's back before us. I guess at this point, I would look to the complainants and ask, whichever counsel from the complainant side wants to address the commission, at least initially, and then eventually we'll hear from, we'll hear from complainants, and then we'll hear from Mr. Brown on behalf of his client.
Good morning.
Good morning. Brian Katz from the Secretary of State's office. As Mr. Richter indicated, we are here today for you to reconsider your finding regarding the Friends of Joe Blystone in light of the committee's failure to act in good faith to affect the terms of the motion to approve stipulated agreement. The stipulated terms of that plea agreement were to avoid referral for criminal prosecution. Friends of Joe Blystone, candidate Joe Blystone, and Treasurer Jane Blystone stipulated to having violated campaign finance laws as alleged by the Secretary of State's complaint. Joe Blystone agreed not to run for political office for 5 years. The committee requested termination of its campaign committee. The committee agreed to fund a Delaware County court case escrow account and pay outstanding obligations and legal fees in this matter. The committee agreed to pay the remainder of its campaign funds as a fine, and the committee was to provide an accounting for its spending from the date of the last hearing until distribution of all funds. Parties agreed to work in good faith to accomplish the terms of this agreement and agreed the Elections Commission retain jurisdiction over enforcement thereof. In establishing the terms of this agreement, the parties relied on respondents' representation that the committee maintained a balance in the account of approximately $180,000. That is why the agreement states after the creation of a $75,000 escrow account, the remaining funds are in the approximate amount of $105,000. Our office repeatedly refused to enter an agreement in which the fine for knowing and flagrant campaign finance violations would be less than $100,000. During discussion this last hearing, commission members repeatedly expressed concern about the potential for abuse by the respondents, with Commissioner Knight specifically pushing respondents' counsel for certainty on the fine amount. Quoting from that hearing, Commissioner Knight said, "What do you estimate the net fine will be? The $105,000 minus outstanding obligations and legal fees." Attorney Brown responded, "Well, the parties agreed that no matter what, it should be more than $100,000. And that was the number Mr. Richter put out, and it will be over $100,000. Sadly, the amount tendered by the committee was nowhere near that agreed minimum fine. Respondents did not reach out to any of the complainants to make us aware of the balance discrepancy or in any way work in good faith to affect the agreement. Instead, the committee remained silent until just before the 30-day deadline was up to write the check to the commission in a stunningly low amount of $39,681.76. As an additional sign of bad faith, the committee wrote "fucking money" on the check to describe the Elections Commission. Third, instead of providing a proper accounting of the committee's funds from the date of the hearing, showing the remaining funds were spent, counsel for the committee provided an incomplete bank statement and what he labeled a certificate of distribution that described 2 of the committee's transactions, whereas now we know there were at least 7 transactions the committee's had since the last hearing. The fourth showing of bad faith was the committee issuing a $30,000 retainer check to the committee's attorney for future legal services. The parties stipulated agreement to provide the committee compassion to pay outstanding legal fees in this matter, not allow the committee to hide money in legal slush funds to pay for other unrelated matters. The committee did separately pay its outstanding legal fees for this matter, as evidenced by the $3,975 check written to counsel 2 days after the last hearing. The additional $30,000 check written to counsel 3 weeks after that for whatever purpose the committee's counsel decided he was able to use those funds for was not contemplated in the agreement and instead should be found to be not working in good faith to affect the actual terms of the agreement. Finally, while the committee sought to terminate, it still maintains a paid website and posts nearly daily from the Friends of Joe Blystone Facebook page. Active committees are not authorized to continue to make publications on committee websites. In the letter to 6 of the 7 commission members, I'm not sure what Mr. Kreitz did to avoid being named in the letter, counsel for the committee attempted to reshape the plea agreement to say the committee had authority to spend the money it has chosen to do, created imaginary confusion when confronted about its actions, denied the express provision that states that the Elections Commission shall retain jurisdiction over enforcement of this agreement, and somehow tries to accuse the Elections Commission of having acted in bad faith, going so far as to threaten the commission if it chose to proceed in this matter. Despite counsel for the committee again attempting to exclude the complainants, it is the complainants that are party to this agreement with the Friends of Joe Blystone, Jane Blystone. The first sentence of this plea agreement says the parties in the above captioned matter hereby move the Elections Commission to approve the stipulated agreement as laid out below. It goes on to lay out what the respondents will do, and the complainants and respondents identified as the parties will recommend to the Elections Commission. The Elections Commission, just like a judge in a criminal case, signs the agreement to acknowledge acceptance of the agreement. It in no way binds the commission to ignore enforcing the terms of the agreement or prohibits the commission from reconsidering the appropriate penalty in light of the respondent's failure to meet the terms of the agreement. In light of the bad faith shown by respondents in affecting the terms of the agreement, Secretary of State's office recommends the commission reconsider the fine imposed by the commission and instead uphold the original contemplated fine in the now fixed amount of $105,000, with the remaining amount to be specifically paid within 30 days. Thank you for your time, and I'm happy to answer any questions you have.
Commissioners have any questions for Mr. Katz?
I guess I had one. And given the view of significant bad faith, curious why the recommendation is really to just uphold the original agreement and not to increase the penalty in some form or fashion.
So I believe it would be a form of an increase in the penalty now knowing where the committee originally started with its funding as of the date of the last hearing. Which, don't quote me on it, but it was roughly $144,000 instead of $180,000. So this new amount would still get to that same $100,000 plus fine that we were originally envisioning.
Again,
Other commissioners with questions?
Thank you very much.
Thank you. Mr. Flynn?
Thank you, Madam Chairwoman, members of the commission. I won't add a lot to this other than my client and I, for over a year now, have tried to tell the commission that something like this was coming. Mr. Blystone, first of all, perpetuated a fraud on this commission. We negotiated in good faith. My client did not want to resolve this issue. She wanted to go to prosecution. We negotiated in good faith. We reluctantly agreed to the situation based upon the assertions that there was $180,000 in that account. There clearly wasn't. Mr. Blystone, Mrs. Blystone, who failed to appear at the last hearing, knew or should have known what the amount was in their bank accounts. You know, we're not 30 years ago where you had to go to the bank to get a bank statement. You can call, you can go online, you can obtain what your bank account balance is. Second, Mr. Blystone has engaged in what I would consider an unprecedented act of direct contempt to this commission, along with all the other ridiculous, slanderous, outrageous statements he's made about, I mean, not only me and Mr. Katz, Mr. LaRose and Mrs. Chambers, but this commission. Even as soon as a few days ago, he is posting publicly that you are all corrupt. Corrupt. And he sent a check with a profanity. I'm an attorney. I would fully expect that any court in this state, if I had a client that did something like that, not only would my client be sitting in jail for 30 days, I probably would be sitting there beside, and for good reason. You know, you can't put a profanity and send it to a governmental body. And this is how Mr. Blystone has acted throughout this process. Earlier, I asked, weeks ago when this year was set, I asked Mr. Richter to issue subpoenas for Mr. and Mrs. Blystone because I predicted, and as we can see, they're not here today. They're not here to answer this commission. They have absolutely zero respect for this commission. They have shown contempt for it. So not only would I recommend the $105,000 fine, I would ask that commission revisit and refer this matter to prosecution. Really, you don't really have any serious contempt powers. And if you did, certainly would be asking something different here. I will be bringing a motion for frivolous conduct. You know, my client and I are here today. We were here last month too, on our dimes. Mr. Blystone, as Mr. Hartman pointed out last month, has not spent a dime out of his pocket for any of this. These are all campaign funds that were unlawfully raised, as he admitted, through cash contributions. So, as I said, I don't want to add too much more than that. We would recommend the fine and to revisit this decision to refer to prosecution. Thank you. I'm happy to take questions.
Do any commissioners have questions for Mr. Collins? Thank you so much.
Thank you.
Mr. Brown?
Thank you. I don't have anything to add to the letter that I sent to Mr. Richter. And when I sent it, I just hit reply all, so I don't even know exactly who it all went to. But it lays out Mr. Blystone's position. We deny the allegations. Well, I have no notice of a lot of the allegations that have been brought up by the two councils before me. So it's hard for me to respond to them because I'm just now hearing something for the first time. But generally, we deny, I'll just issue a blanket denial of everything that they said. Mr. Blystone has, and I'll just summarize really quickly because I don't want to get away from my letter. But just in summary, he's given up all the money that he had. And the thing that I guess bothers me is when we were negotiating this, I said many, many times over and over again that we didn't know exactly how much money was in the account. And that the deal that we were writing was supposed to be an agreement to agree, and that the details of that would be worked out later. Because I didn't know, I mean, I was very clear, I said it many times, I didn't know the exact amount of money that was in the account, but I thought that it was around $180,000. So that is why I also included a bank statement with the certification, because it showed the number that I was actually working with, which I believe was $149,000. So I don't know what else to say to you. He has given all the money up. He doesn't have any, there's no money left in the campaign account. The only issue is how much of the legal fees money should be forwarded to the commission. And I stand by everything I said in the letter about the inappropriateness of a demand unilaterally from the executive director. I hope you noticed in that letter, I did not take a personal shot at Mr. Richter. Did not criticize him personally. I criticized the action that he took, and explained why in detail why I thought it was inappropriate. But I guess my view is all we need is a number. How much of that legal fee do you want us to forward, and how much do you think is reasonable for us to cover the legal fees or the campaign? And I'm glad to entertain what that number is going to be. But other than that, money's exhausted. And there was one thing, I do think that Mr. Katz's quote was appropriate, that based on the number that I thought we had with 180,000, I thought that the amount of money that would be available would be over $100,000. And I obviously was wrong about that, and I'm sorry about that. I was going in good faith in what I thought the number was. But I do think that ultimately it will be over $100,000 because there's $75,000 in the Delaware account that I think all of it will end up with the Elections Commission in the end. So, but that's not up. There's other, there's a judge that has to make a decision on that. So that's my position. I assume everybody read the letter, so that fills in the things I'm not talking about right now. That's letter states our position. Thank you. Unless you want me to answer questions.
Anyone have, commissioners have questions of Mr. Brown?
Yes, I have one question. Did you personally hand the check from the committee to Mr. Richter?
I did, and I think you're asking, did I know that he wrote that profanity on there?
That's where I'm going, yeah.
It was in an envelope until I handed it to him. I did not see it.
You're not aware that that was on the check?
No, it was on the check, no.
Fair enough.
I didn't even look at the amount. It was in it. I don't know if you remember, but it was just me and Bill in the room. I had an envelope in my pocket. I pulled out the envelope and handed it to him. And I didn't put it there, so I can't apologize for Joe, but as much as I can, to state that I'm sorry, I do think that was totally inappropriate. And if I had seen it, I would not have given Phil that check.
Right, and that, I mean, I guess it's a 3/4 comment, half question. As Mr. Katz noted, I mean, I specifically asked about what the net amount of commission would be. And certainly from, I'm one vote of 7, but had the answer been different, that we were going to get significantly less, I would have not been in favor of the agreement. Certainly at 39,000 and change, I wouldn't have even considered it. So, if it were 95,000, but I mean, you're talking over 60%. That is a material miscalculation, right? I guess I'm interested if you have any additional commentary regarding that.
Yeah. Well, the point of the deal was for him to get all the money that he had left over, and that's all he can get is what he's got. So I think that the consolation is if he can give you what he has, and he's given 100% of it up.
Okay, but if that number is not sufficient, then perhaps there are other terms that could have been considered.
Yeah.
And maybe he's never permitted to be a candidate again. Maybe you consider there's lots of other, avenues that could be explored if the number is a 60% miss.
And that's what I'm suggesting is rather than a unilateral demand, which the executive director, I don't think can make on his own. If you just said, hey, let's get the parties back in the room again, and let's go off of the numbers that we knew are correct, now that I was able to go back and look what the actual number was, that we can, because it was just an agreement to agree, we could work out the details from there. And I belief at the time that was the plan, actually, was that we were going to go back and get the actual numbers and work out the full, because if you look at this agreement, it's not written as a contract. It doesn't have any provisions about whether outside agreements can be part of it, like that would always be included in a contract. It has ambiguities in it, and one of the reasons it's ambiguous about the actual amount of money is because I didn't know what the actual amount of money was. That's why the The agreement itself, the language itself is ambiguous about what they not actually want to be. So I said, it says approximately 105 because I thought that was approximately what the number would be. That word approximately was one that I asked for. Also, I was the one that wanted the good faith provision that's in there. And one reason I wanted that is because I knew I didn't know exactly what the number was. So we could look back on and say, hey, did we at least try to work it out in good faith? And to me, it's not about the specific amount. It's about 100% of the money needs to go towards some sort of punishment. The only question is how we're going to allot how that money's going to go. And the 75,000 that's going is a punishment as well. So Blyson has no problem with changing the numbers around. But he only change the numbers he has. He can't give you anything more than what he has. So if we want to work out the details of what this number, because there's 3 numbers that are in play here. If you want to move the dials, we don't have any problem with that. I don't think we have any problem with whatever the number is. I mean, the only problem with Delaware County is I can get to 75,000 back, but we'd have to do the judge would have to order it. And so we'd have to do some sort of a joint motion to have the judge move that money. But at the end of the day, it's either going to one of the complainants or it's going to the judge's never getting any of this money back. It's all gone. If you want to turn the dials on what the amounts should be, that's what we should be talking about.
Well, with all due respect, may I say something? If we're supposed to act in good faith, then I guess my question, as well as what Mr. Knight was, I think, getting at is perhaps you don't throw out a specific number. And 105 is thrown out again and again and again.
Actually,
But
approximately 105 is thrown out.
I'm sorry?
Approximately 105 is thrown out, which is a description of how much money is left in the account.
I understand, but I guess why not a number at all? If you don't have any idea, why would you throw out? Because there is a huge disparity between 39.8 and 105. So not only did you act in good faith, but we did as well. And the attorneys on the other side and the complainants were acting in good faith to say, okay, you think approximately 105. 105, approximately 105 is not 39.8. So I think that the good faith goes both ways. It doesn't just go, we trusted you your word. And to be honest, 105 approximately or about that was thrown out. I'm looking in your letter, which I've read over several times. It's in here a lot. So I guess that would be my question. And I don't know if anyone else on the commission. I know Mr. Knight, I think probably has that same thing. I'm Mr. Lyle. I can't speak for anybody. I would welcome to hear their comments on.
I just have, yeah, thank you, Madam Chair. I guess where I'm feeling as though bad faith was put forth by the respondent is that this commission waited an extensive amount of time for the negotiations to take place. As the previous case we discussed and talking about, back in the days of old when you had to go to the bank and physically get the bank statement from the bank teller. Today, you can call, you can go online, which the respondent could have gone online, could have called the bank, could have gotten the exact amount that was in the account, and even identified checks outstanding at that point in time. That wasn't done. That was irresponsible, and for me, that was bad faith to come in and say, approximately $105,000, and now we're going to give you a check with a nasty written note on it for $39,000 plus. So for me, counsel and the respondent acted in bad faith.
Sure. I would just like to ask, so were the parties aware that the legal fees would be for the equivalent of the remainder and similar nature of the balance of the in the account when these negotiations were made?
I'm sorry, I don't understand any questions.
It said 2 days after approximately $39,000 in legal fees were billed and paid for. Was that
No, 3,900.
3,900? Okay. That makes me feel a little bit better.
That's cheap.
And I guess,
Then on
yeah, I just want to say, for the
Yeah,
integrity
container.
of the commission, all of the insult, slander, things that have been said and done, I'm sure the majority of us would rather every money be returned to the people that actually contributed. There's zero desire to have this money in our accounts. So the things that have been said are inappropriate at large, in my opinion, professionally. But if there were a mechanism for achieving that, that's something that I would like to see personally, but I don't know that we can even achieve that at this point.
Thank you. Mr. Ryan.
Yeah, Mr. Brown, I'm just very troubled by your arguments, number one, particularly with respect to ambiguity. I understand about ambiguity and how things can be ambiguous. However, the fact that Mr. Knight, as Mr. Katz pointed out, asked you specifically, I've reviewed the tape, and I'm sure commission members have too, several times, he asked you, what is the net after the contract, after the legal fees? You specifically said it would be over $100,000. So how you can make an argument about ambiguity is beyond me, because you clearly stated to us what the intent was. And when you look at language, you have to look at the, as you know, you're an attorney, the clear language, and you also have to look at the intent. And you stated what the intent was. So I got to tell you, I feel that we've been hoodwinked, we've been duped. I don't disagree with this, Mr. Pollitt said. And I'm glad you put the good faith in there, but I got to tell you, I think it's unethical, in my opinion, nobody else's, what you and your client did. I think it's totally unethical that you would come here, that you would not have the facts after it's been pointed out how long we've been dealing with this case, and you wouldn't know specifically what the amounts were. I find it hard to believe that you guys didn't know what that was, or at least one of you didn't know. Let me finish, please. Know what it was. And I also disagree with you about that this isn't a contract. Sir, it is a contract. Everybody signed it in good faith. And the fact of the matter was, you had pointed out, Mr. Richter said, Mr. Richter did not sign the contract. The chair, Mr. Bailey, signed the contract. So you're aware of that. On behalf of the commission, it wasn't Mr. Richter. And I got to tell you, I don't always agree with Mr. Katz. He knows that. But I got to tell you, he hit the nail on the head. Everything he has said, I agree 100%. 100%. And just like Mr. Knight and Ms. Tavares, if I would have known that figure was $39,000 and some change, there's no way you would have got my vote. There's no way. We would have moved it to prosecution. I'm sure of that. Okay? The violations that occurred, we are being very lenient, I thought, with that agreement. But I also understand the importance of settlement. But then when you come and throw that in our face and dupe us, it's troubling to me. I just have to tell you, it's very troubling with what you, your client, I believe, did to this committee. And to, more importantly, the citizens of the state of Ohio. I'm done.
Might I add one last comment? Last for me. I was gonna stop short of saying this, but since Mr. Lyle very eloquently said something similar, I want to build on it. When I read this agreement on that day, I saw the ambiguity. I'm not an attorney, but I deal in business contracts every day of the week and have been caught ambiguity before. I asked that question specifically to prevent this conversation, right? The whole point of that question was, after spending 3 or 4 hours negotiating to not request you go back and be more specific, in good faith and get on the record what that number was to prevent ambiguity and to prevent these exact conversations. And, I watched for about 3 hours while, your client and a few of his colleagues, kind of sat around and talked. They could have walked to Huntington Bank and got the number if they needed to. To stand there and say, right, that, you were unable to validate the number and that this was ambiguous, it insults my intelligence. It really does. And I'm not a very smart man. It's hard to insult that intelligence, but you did it. And I was gonna hold back, but after Mr. Lyle, kind of gave his view, I really feel the need on the record to let that be known.
All right, can I respond? At the beginning of that series of comments was the question. Sorry, my head is spinning a little bit. When we started negotiating, I wrote an original draft of what I wanted the agreement to look like. And in that original draft was something to the effect of all the remaining funds will go to the Elections Commission. And Mr. Hartman got a hold of that, and what you have is what he drafted. And so my thoughts were that I would be able to get the exact number, and then we would be able to work out the details, and that the goal was that all the money that he had was going to go to one of the 3 categories. And I understand what you're saying, because obviously I regret that I said that the amount was going to be over 100,000, because that was genuinely what I thought at the time. And I know you're saying that he could have taken measures to find out what the exact amount was, but the reason that was the question that was at the beginning of this, was the reason that he didn't go and look up what the actual amount was because my thoughts were we were outlining the agreement and that we were going to do the specifics later. So I'm not saying that any of you are wrong, or I'm not arguing with that at all. I'm just saying that that was genuinely what I was planning on doing, was just working out what the numbers were going to be after I had an opportunity to do that, because there were outstanding checks, as you saw in the statement. So I think that, so to me, what this is about is, what do you want out of this? So if you want us to forward the rest of the money that was for the legal fees, I can't do it. Mr. Blyson has to make that decision, but I will urge him to do that if that's what you want. But like I said, he can't give you anything than what he has. I'm sorry. I mean, I guess it's just, all I can do is just say that is genuinely what I thought the amount was at the time. But I was very clear, and I said many times that was what I said. I didn't know. That is my best guess of how much money's in the account. I mean, I just can't say enough that was, I said it many times that day. And the reason we put that language in there was because I wasn't sure of the exact amount. And I understand what I said to you at the meeting.
To me, that's where we go.
I understand why you're upset about it. I just put it that way.
Mr. Pullins would like to respond.
Yes, and just mainly to answer Commissioner Hagan's original question was, did the parties expect all these legal fees to be part of this? And no, we didn't. The respondents, Mr. Brown, have set aside an amount of $30,000, which was not discussed, anticipated, or expected. At this point in the Delaware case, the only thing pending is our abuse of process claim. And I must again point out to the commission this civil lawsuit against my client was filed and has been paid for 100% with campaign funds. There's not much there to be done. Other than we believe that Mr. Blystone, if he's got to make a decision now, he has $30,000 to play with to drag out an appeal or whatever. So yeah, the original question was, no, we did not anticipate that. We would not have signed on to an agreement that said, well, for example, we were told several times the amount was approximately $180,000. Now, as an attorney, when we get an assertion from opposing counsel, we have to take it to be truthful. If the whole system breaks down, we can't do that. And frankly, if there had been a $5,000 difference, a $10,000 difference, we probably wouldn't be here. But there is a $65,000 difference. $35,000 that, if you look at the checks that were provided to the commission, were lots of checks written to Mr. Blystone. Others to his friends for refunds that may or may not be proper. And then, of course, the $30,000 for future legal expenses. So I hope, Madam Commissioner, helps.
Commissioner Hoffman, may I ask a question about $30,000 future fee? Who is that directed towards?
Well, the $30,000 is deposited in Mr. Brown's trust account.
All right, it's interesting to me. I mean, we heard a case earlier today of a person who's fully compliant, has got everything in order, had $2,000 wagered against them personally for an account that was out of line for several years, and with a wife dying of cancer. I think that we look at all cases fairly with integrity and with an understanding that these are complex situations. I just think the level of slander it's just been interesting, to say the least, given, I think, the intentions of the commission to give full and fair hearings and allow for all the facts to be presented. We still haven't heard from them in the back of the room because we gave all of you the full effort to settle this, and we're still being attacked. So it's just interesting to me. That's all I really have to say about it.
Okay, I just want to respond. So the actual, I'm reading from the actual motion that the stipulated agreement that we have, which it has a line there, notwithstanding any outstanding obligations for legal fees in this matter. So clearly, legal fees were contemplated, and no specific amount was contemplated. So therefore, I think the issue today is what should the amount be? I think that's the only thing we're really discussing here. And we are had to discuss that. I agree that 30,000 is a lot. So just tell me, how much do you want us to forward to the commission? How much do you think is reasonable legal fees? And we'll give you that. And at the end of the day, all the money is gone. He's been punished by having to give out every dime that he had.
Well, with all due respect, to deposit $30,000 as a retainer, if this was all resolved with forwarding the money to the commission, there should have been no need for a future retainer of the fight is over at that point, if I'm understanding.
There's a dispute in a common pleas case.
Okay. Thank you.
Address the question again.
Absolutely.
Thank you. First, as he pointed out, it was outstanding legal fees in this matter.
This case, yeah.
As of the date of that hearing, which is, I borrow your copy if you'd like me to read it again. Notwithstanding any outstanding obligations and legal fees in this matter.
I need to find obligation.
Outstanding obligation is something owed to a party as of the date of the hearing.
Mr. Brown, please let Mr. Katz speak. We've been very respectful of you. Please be respectful of Mr. Katz.
It was fully contemplated that counsel for the respondent would have a bill for this matter. It was then paid 2 days after in the amount of $3,975. Additional retainers for $30,000 in legal fees that I believe he tied to a different case outside of this matter not contemplated in this agreement. Additionally, the idea that the money's all gone or that that's all there is or something, so let's just kind of turn the dials, is also not correct. This commission has on multiple occasions, as was just addressed, personally fined individuals. So again, whether or not the committee has the funds available in a checking account today to pay the fine is not relevant, as there are other parties beyond the Friends of Joe Blystone that could be liable for that fine. And then finally, just to clarify the recommendation as it was referenced, a outstanding escrow account exists. Our recommendation is that the parties be fined $105,000 plus any amounts remaining in the Delaware County escrow account. We are not asking for that amount to be included in the $105,000. The fine should be $105,000 minus any amounts already paid to the commission as a fine, plus any amounts outstanding in that Delaware County escrow case. Thank you very much.
Madam Chair. Mr. Katz, if I could, please.
Yes, please.
Interested in your thoughts on this. In light of what appears to be demonstrated lack of good faith on behalf of Mr. Blystone, what are your thoughts on this commission vacating the agreement, setting the matter down for hearing, and putting all the issues, including referral for criminal prosecution, back on the table? What are your thoughts on that?
Thank you. So while we are not necessarily objecting to criminal prosecution, the idea of having a hearing is generally pointless. The complainant not in any way deny the allegations that the Secretary of State's office has laid out, and I don't believe denies any of the allegations made by any of the other complainants either. So there are no questions of fact. And the question is, what should the resulting punishment be for those flagrant continual violations, as well as now compacted by the bad faith shown by the parties? If you are considering criminal prosecution, we are welcome to do a hearing again so that we can question the witnesses. At this moment, they are not appearing for your hearing, so it would be a bit of a challenge to question them because they are the when dealing with the cash transactions that they manage, they are the only good witness known to explain what happened. And so just besides them coming forward and again admitting the allegations that we had.
You would agree, though, Counselor, that this would be one of the options that this commission has to go ahead and vacate that agreement?
Absolutely.
Mr. Holmes, would be interested in your thoughts on that.
Thank you, Mr. Kreitz. Well, as you recall, our original recommendation was to have a full hearing into where you recommend prosecution. I think all the facts are before you at this point. And as Mr. Katz alluded to, Mr. and Mrs. Blystone don't show up for these hearings. You know, they're not here today. They were ordered to be here. And they're not here today. So I think my only objection to doing that is, again, myself, Mr. Hartman, Mr. Katz spent a lot of time preparing for a full hearing as we did before. We show up and Mr. and Mrs. Blystone, which could really be the only possible witnesses, will fail to appear. And we've kicked this can kind of down the road another month or two, you know, however long this process takes. To me, the fines that Mr. Katz has suggested are sufficient, but as a way of deterring future conduct, I do think this should be referred to prosecution. Really, if the commission had contempt powers, I'm sure they could be executed. They don't have them, and maybe that needs to change. But I don't think we gain anything by having a hearing because I don't think Mr. Blystone and Mrs. Blystone will participate in that.
Thank you.
Thank you, Mr. President.
Mr. Brown, do you have a response to that, sir?
Thank you, Mr. Prince. Okay, so I believe the question is,
Why shouldn't this commission just vacate the agreement in light of what appears to be substantial lack of good faith and set the matter down for hearing and put all the remedies back on the table, including possible referral for criminal prosecution if the evidence should so merit?
yes, sir. So two responses. It's clear I'm not convinced you that there was no bad faith. But I'm reading the language of the second paragraph. And I've read it a million times in the last 2 weeks, or probably less than 2 weeks than that. And to me, the only thing in this paragraph that is questionable is the preposition which are in the approximate of 105,000. And so I've taken the committee members at their word that that amount was material to your approval of the agreement.
That's what was commented, yes.
But to me, I was focusing on the all remaining funds currently held. And then this 105 was clearly an estimate. And that's the only thing that we're disagreeing with. Everything else is approximately agreed upon. I think the issue of how much the legal fee should be, the outstanding obligations and legal fees in this matter, that you just have to give me a number, what you think is appropriate there. And I've already said, we'll give you whatever we can reason, whatever we can agree on is appropriate for that number, we'll forward to you. Only thing I said in my letter was that we wouldn't forward all of it because the bill that you saw taken out in the January bank statement or the February bank statement was for January's work. So there is one payment left for February's work. I'm wrong, it was for December's work and there's one payment left for January's work. And it's a very small amount. So I think we can probably work out this last thing about what the outstanding obligations legal fees in this matter are. So to the extent that you believe there's bad faith, I'm sorry that you believe that, but that's our position on the good faith argument. So then the second part of your question is, okay, why should we not have a hearing? I think that the committee agreed with me at the last hearing when I said that the depositions cover every imaginable question that you can have. I think that if you look at the depositions and ask yourself, is there any questions this committee could ask that haven't already been asked? And you believe that there are more questions, then Joe Blystone will not deny you a hearing. Jane Blystone submitted herself to the hearing in May on very short notice, and we objected, vigorously to that hearing for multiple reasons. And she went ahead and went through it, and we never did get to do our direct examination, which we objected to and have a big problem with. That it was, I think over 4 hours of cross-examination with no direct examination the day before the election. So she's going to submit to that, and Blystone I don't believe he's indicated he's not going to testify if he's subpoenaed. So my recommendation, I guess, is look at the depositions. And if you feel like there's a question you don't have answered, then have a hearing, and nobody's going to object to that. But I think you're going to find that every imaginable question is asked in that deposition. And then in terms of undermining the agreement, I've already stated in the letter how my mouth is getting dry. I'm sorry. We've stated in the letter how we'll react to that.
So are you suggesting then that there's sufficient evidence in the record right now for this commission to go ahead and decide if they choose to vacate the agreement, to decide to go ahead and refer this case for criminal prosecution without any further hearing? Is that what you're
I
saying?
think that would be in breach of the agreement that we have.
I'm sorry?
I think that to do so would be a breach of the agreement we have. But Mr. Blystone is saying, so I think a criminal referral would be a breach of the agreement that we have. But I do think that he's saying that he'll submit to any questions that.
Counselor, how can that be a breach of the agreement if we vacate the agreement and then proceed to the testimony that you said is already in the record?
Because I believe it's a binding agreement and it's a contract.
One final question. Can you explain to this commission why your clients aren't here today?
Yeah, it's one.
Thank you.
It's a current time program.
Neither.
Yes, Mr. Richter, just, I know I asked this question. Could you, in light of Mr. Kreitz's question, could you give the range of options that the commission has at this point?
Well, as it relates to, where we are right now, I think we can further clarify the agreement that we currently have. Mr. Brown has been requesting that. Mr. Katz has commented on that. Mr. Pullins has commented on that. I think we could do that. As it relates to voiding the agreement, moving on from there, I think that's certainly a possibility as well. Were we to do that, I think one of the first things we would be inherent on the commission is returning the funds that we've already accepted. And, in order to put us back at what I want to call it, an even place, ground zero. However, we'd have to do that, and then we could move forward again. I think that based on some of the representations we've had, some of the comments, I should say, that we've had this morning, thoughts that I have, certainly we have, within the agreement, we have the admissions by the parties.
Let me stop you for one quick second. Sure. So we have option, so we have option A. Okay, that's to
Further clarify.
Option B would be to vacate the agreement and call for schedule full hearing.
Correct.
Okay. Now, is there and I don't mean A1, is there a third option? Does statute require that there be a full hearing before you could refer it to prosecution?
I don't think that the statute requires it, but it is generally, you need to produce, I think, sufficient evidence to establish that referral is the proper thing, and then to be able to present to a prosecutor sufficient information to allow the prosecution to proceed. Either that or, we have had, I can think of one particular case where a party came to the commission and said, here's our violations, please refer us to the prosecutor, because we work with the prosecutor, and we ended up doing that based on that agreement. I don't see that occurring here. And so without that being the case, I think if we're going to refer a matter for prosecution, I think that the record would need to be developed. Because yes, we have, in this agreement, there are admissions, but what really are those admissions in terms of the full breadth of what I think a prosecutor would require in order to proceed forward? And so if we're going to void, I think we would need to have a full hearing, allow testimony, allow cross-examination, the whole thing. So that then once that's done, the commission makes and then presumably the commission would still have to find, that the appropriate thing is to refer for prosecution. At the conclusion of that, then put the record together, send it along for a prosecutor. And then really it's up to the prosecutor to determine, whether prosecution is right or not. Over the years, when we had false statement cases, we would produce a pretty good record in those times, send it along for a prosecutor. And I can remember on a couple of occasions, we got a letter back from the prosecutor. Thanks, we appreciate your efforts and thanks for sending us along. But, I don't believe that the merits prosecution, we're not going to prosecute it. That's always a possibility. And I think that's part of, at least in my opinion, one of the reasons why we went down the agreement road here was, once it gets beyond us, we don't control the prosecution aspect of it. That's not and it wouldn't have been, but you don't know. And so this was, the parties controlled this, came up with the agreement and worked it through in such a way that we felt it was equitable.
Madam Chair. May I address Mr. Ricker? Phil, I would agree with that. I think that a full record would have to be developed. If this matter is vacated, if the contract, the agreement is vacated and sat down for hearing, I think there has to be a full-blown hearing so that there's sufficient evidence in the record to demonstrate why there's been a referral for criminal prosecution. Or what are the other options? If we were to vacate, set it down for hearing, obviously referral for prosecution is a possibility if it's supported by the record. If that decision is made by the board, are there any other financial options that can be considered by the board as well, or is that an exclusive remedy?
It's a one or the other. If you look at the commission's authorizing statutes, what it essentially says, the conclusion of the hearing, the commission shall do one of these things.
It's or
Find good cause, impose a fine, or refer the matter for prosecution. It's one of those things. It's not, at least in terms of a particular person against whom we found a violation. I harken back to what, at least some of you are aware of what we did in the Elkins case, where we made findings against the committee, the treasurer, and Mr. Elkins, and we imposed fine sanctions against the committee and Mr. Elkins, and the treasurer, but we referred Mr. Elkins because we had developed enough of a record as it related to his activities that didn't necessarily indicate that the prosecutor or that the treasurer should have been set for prosecution. And so we certainly have an ability to, for want of a better term, bifurcate, how we go about opposing or imposing a sanction. Yes. Here, we took the agreement from the parties that there was a violation of the statutes from the three parties, and we imposed, this one particular sanction. But I don't know why why the entire 100,000 that was essentially asserted by Mr. Brown that would come to the commission couldn't be made. It doesn't have to be made up from just committee funds. It can be made up from wherever else, because on his client's behalf, he made the comment that commission would, and based on your question, the commission would receive no less than $100,000. That could certainly be, I think, a part of the agreement.
Matt, may I follow back up on that? Phil, in the event that we go to a full-blown hearing in this matter, and that's if, we're just kind of feeling what the options are.
Sure.
One of the options, obviously, if the evidence is there, is to refer it for criminal prosecution. If this body would go ahead and review it and make a determination not to refer for criminal prosecution, could then have the panoply of financial penalties, right? That could be assessed as well. What are the penalties that would be, financial penalties we'd be looking at in this case?
I think the primary one, there are a variety of, okay, from 100, and I think the primary one that could come into play is $100 per day for improper filings remaining outstanding. And certainly Ms. Chambers' complaint that was filed in October of 2021, I think it was, asserted those statutes, as did the complaints that Mr. Hartman's client brought, Mr. Katz, the secretary's referrals, indicated that, there has been a failure to file full complete campaign finance reports. I don't have it here in front of me right at the moment, which particular reports those were, but I know from previous conversations that I've had with Mr. Katz in previous presentations here, I think that goes back to almost the beginning of when he started running, which would have been pre-primary, post-primary, probably even more pre-primary, for the two boards that have never really been considered full, complete, and accurate. So that you have the ability to assess that time frame and then impose a sanction of up to $100 per day for those outstanding amounts.
Thank you.
Yes, go ahead. So,
No,
sorry.
that's okay. Mr. Craig's question answered my question. Go ahead.
Yes,
I'm fine, thank you.
yes, Executive Director Richter. And just trying to anticipate and close loophole on any potential procedural defects or claim of any procedural defect. Given the pending departure of 2 commissioners, there's no issue if a hearing was set and you had situation A where the 5 remaining commissioners are available for that hearing,
Mhm.
or Commissioner B, or excuse me, situation B, where 2 new commissioners have been appointed by that time. If those 7 or those 5 were the, hear the evidence, go and go forward and make the decision, is there any argument, not ridiculous argument that could be made, but any procedural defect given the participation of the previous body?
No, because to this point, the hearing, at least as I anticipated, let's say we do avoid it and we set it again for July, just to pick a month out. We set it for then. It would be a new full and complete hearing at that time, at that point, with all the evidence presented to the commission for the commission's consideration at that point. And so you would have before you, to me at least, a complete record that the commission can assess in terms of the evidence presented to it. Because yes, we did have some of the testimony from Ms. Blystone at the initial hearing as a result of the expedited matter. But what at least, in anticipation of the 5th, when we were going to have before the 5th, it was going to be a full new complete hearing with testimony from various parties placed before the commission for the commission then to consider, regardless of what was a part of the previous hearing.
Chair, question for the director. Is it possible today, if the parties that are here are interested and willing, if we were to execute this existing agreement, that they could go back to the drawing board and establish something to propose to us today, or we still have to go to a full hearing at a different date?
You mean to come up with kind of a new agreement of sorts?
Yes.
Well, that essentially would be option A.
If I can answer for that, respectfully, no, the Secretary of State's office will not be entering a new agreement with the Joe Blystone Committee.
Good. And we don't want to enter into any kind of agreement either, Madam Chair, if they're not here.
Right. Yeah, Mr. Hartman's not present today.
Madam Chair, one for the executive director. Since we have a binding agreement, the parties signed, can we not just enforce that in a court of law? Have a judge make a ruling?
I think we certainly can have that opportunity. We could have that opportunity. Yes.
I mean,
If it comes to that, if the parties are not, if we're not satisfied, let's say, let's put it that way, I think we could have that opportunity. Yes.
Mr. Brown?
There are benefits, detriments, I think, to both sides to potentially going forward in that regard, but I don't know why they couldn't do that.
I want to give Mr. Lyle that opportunity to.
Right, so-
Did you have another comment? Mr. Lyle?
No, I'm fine.
Okay. Mr. Brown?
Thank you, ma'am. That actually was the point of my letter, was that we have a binding contract and that we can either work it out among ourselves or a court can work it. I think I said that explicitly in the letter. We also could have mediation too. And I think that could be helpful to work out, the details of entertain that. I've done many agreements where a magistrate at the common pleas court would actually oversee a mediation where we work out the details as well. So I think that's a good option.
Sure. Mr. Executive Director, could we vacate the agreement. And then, you know, it's just take the criminal prosecution aside, which would require a full hearing. Could we, as a commission, make a new determination today of whatever it is in terms of fines? And we have, right, you know, all the position information, all that history, you know, could we just vacate and make a motion and do a whole new set of fines like we do in the other case?
Mr. Hartman is not present. I think that presents a potentially fatal issue.
Yeah, and see, that's, we did what we did earlier because it was just between Mr. Jack and the commission, essentially. You know, we made a finding against him and reconsidered it forward. Here you have the agreement that's in place, of which the commission is certainly one of the parties. But there are other parties involved in that agreement. And so I think we would have an ability to just void the agreement. And then it's void from the commission, because the commission is the ultimate decider of whether there's a violation or not. You know, so that we could do that. But there are other parties involved in the agreement. And so just, you know, making some of the unilateral determinations that you kind of outlined there, I wouldn't feel comfortable with the commission doing that. Based on the fact that there is an agreement in place.
Is there, let's say, right, for those reasons, we don't, well, I guess. I mean, to be blunt, I mean, I don't see how we I don't see how we can trust the agreement to move forward at any level of good faith, no matter what would be agreed to. So then the question becomes, right, and again, opinion of one, when we make that, you know, determination, what I don't want to have happen personally is we return the back to the Blystone Committee, and then by the time we determine whatever, that money is gone, right? And then we're here without any leverage, we're setting fines against, something we will never be able to get back. I would like to be able to keep that in escrow in some way, shape, or form if possible, regardless of what we do.
Madam Chair. I guess to respond to Mr. Knight's comments, we still have the opportunity to go after the Blystone personally, if those dollars aren't there. I mean, I think the Secretary of State has been clear. I think the agreement was clear that it was going to be at least 100,000. We were told 105,000. If they spend up the money, they're still going to owe 100,000, 105,000. We can always use that as another option to be both the campaign and the candidate themselves.
Can I respond to that?
Treasurer.
Yeah, so
Treasurer too, right?
100% agree, except for I view a world where regardless of who we find, it's going to the AG's office for collection to never be collected, right? So we can find the Blystones as individuals, and I don't anticipate ever being able to collect. So if the 39 and change goes away, there may never be a fine imposed of any sort that is actually paid. That is my concern.
Fair.
Mr. Pullins.
Yes, Madam Chairman and Chairman, thank you. I was going to suggest something similar. We've all agreed it's a valid agreement. It's a valid contract. It's in place. One of the parties has not lived up to the agreement. There is $65,000 that is owed from the respondents to the commission. And the commission should make sure, make it clear that they owe that money and it should be paid. And, you know, if it goes to the AG's office, it goes to the AG's office. But, you know, that money should be paid.
Thank you. May I respectfully ask for a 5-minute recess? Is everybody amenable to that?
Sure.
Okay, so it is 12:05 right now, so if we could be back here at 12:10, I would appreciate it. Thank you.
Thank you.
Stay by the second.
I know. Down.
You want to find that, Chris?
I was looking.
Mr. Brown, oh, are you coming back, right? Okay. Well, you packed all your stuff. I was just like,
Yeah, I just got legal stuff in here. Right now.
this session back into order.
You're really good. It's all on the wrist, isn't it?
I tracked last night, so I can.
She's gonna be using that at home because her sons come home from college.
Chris is going around trying to put it in the basket when we normally take recommendations. She'll put it in her briefcase and take it home.
So, okay. So we've heard from the complainant and the respondent. We've heard from the commission. What do we feel our next steps are? Or what are our options for next steps, Mr. Director?
Well, Mr. spoke to it. And I think that the simplest approach, and presumably the best approach, is based on the representations that were made to the commission by Mr. Brown at the January 5th hearing, which is that the commission would receive no less than $100,000. That comment was made on behalf of his clients. There's an agreement in place that says that would come to us. We have violations that were agreed to by Joe Blystone, Jay Blystone, the Friends of Joe Blystone, wherever that money comes from. But certainly there, one of the expectations was that campaign committee funds would be brought down and used to do that. But if Mr. Blystone has to make up, Mr. Blystone, Ms. Blystone, whoever has to make up the difference to bring it to that amount that was promised to the commission, I think that's kind of where we head out. That's where we head at this point, to have that amount be fulfilled by the parties to the agreement. If we make that kind of a finding, I could put that in an order by the commission in terms of further enforcing the terms of the agreement. I think certainly the commission will demonstrate that it's acting in good faith based on the representations that have been made to the commission.
Okay. So going off of the number of no less than 100,000 to be paid, taking out the 39,681.76, it would leave a balance of 60,318.24.
Okay.
And Madam Chair, just one other clarification to the executive director. There was also language that talked about any remaining funds in the escrow after those bills are paid. Or is that still a part of the agreement?
That remains as a part of the agreement. Yeah, that's a part of the agreement, that whatever comes out of the monies that have been paid into the Delaware County Clerk's office would come back to the commission. I think that's, that is certainly what all the parties understood and agreed was going to happen. And if it so happens that all of that money is otherwise used as a part of that, Mr. Pullins is involved with, I think the parties have said, okay, so be it. Certainly, I think there was a certain expectation by, the commission, by myself, by Mr. Katz, possibly even Mr. Hartman, that some of that money might come back to the commission, but everyone was in agreement that that was an acceptable amount to allow to be placed there for resolution of that matter. And then if there's anything that isn't utilized as a part of that resolution, it comes back to the commission. That doesn't change. And really, the terms of the agreement doesn't change, aside from the fact that it says all remaining funds currently held by the campaign committee or the approximate amount shall be paid to the commission. Well, we were told that at least $100,000 would come to the commission by the parties, by council on their behalf. And so I think we have every reason to believe that we should receive those funds. And regardless of whether it comes from the campaign committee or the other respondents in the case, I don't think that's an unreasonable expectation.
That's a question. Who manages and controls the $75,000 escrow account?
My understanding is, Mr. Poles may be able to speak to that, but now that it's in place with the with the Delaware County Clerk's office, it's in the control of the judge of whatever cases they're pending. And let's say the judge comes back and says, sorry, Mr. Pullins, you don't get anything. At that point, $75,000 would come to the commission, presumably, because there wouldn't be any payment. And the alternative, if there is some other amount that is set aside to pay for the results, whatever the result may be of that case, that amount goes to Mr. Pullins' client. And then the remainder comes. Please speak further if I
Yeah,
misspoken.
that's correct, Mr. Richter, and to Commissioner Knight. Right now, that's held in escrow. It's pursuant to court order.
And it's there, it's been
It
placed.
is there and it has been placed and it's sitting there. You can see it on the docket, the public docket.
Great.
It's sitting there.
And just as an example, from my understanding, if the judge makes a determination that there's 50,000 and there's 25,000 left, how does that flow to the, like, who signs what to get it to send here? How does it flow happen to get to the?
Well, you know, we provided the judge, the court with a copy of this agreement, signed agreement, so the court is aware of it. And I believe his initial order accepting the money addressed that issue.
Okay.
But it's clear to the court that if those funds are not awarded for damages or attorney fees or anything, that it has to go directly to the commission.
Thank you.
Just.
I've done deals like this before, so the judge ordered the clerk of courts to cut a check to the commission, and in the mail, you'll receive an actual check from the clerk of courts that will have the amount.
Okay, wonderful, thank you.
Mr. Richter, I just have a follow-up question. So there was the 75,000, there was a 30,000 that was set aside for attorney's fees for this case, correct?
Well, there was $30,000 set aside that was listed as a retainer.
For the matters up until the 5th?
No, I believe Mr. Brown said that was for a different legal matter.
Right. I don't think it's ever been, did make mention earlier today of certain billing for January. You know, that was, he can comment further. But I don't know why, it was never explained to me why the $30,000 was otherwise set aside specifically, just that it was.
Do the other parties have any comment on the 30,000 that was set aside?
Thank you, Commissioner Tavares. I think I addressed it earlier, but we had no anticipation it would be set aside. It should have been set aside. But I think as far as we're concerned, the commission should be concerned, there's approximately $65,000 owed to the commission pursuant to the agreement. Now, whether Mr. Blystone, Mr. Brown want to take that out of his trust account and pay it, or Mr. Blystone wants to sell the $184,000 RV bought with cash, that's immaterial to us. You know, the 65,000 should be paid.
Thank you.
I guess my question, Madam Chair, would be, I don't think anybody's in disagreement with the 65,000. The question is, and I'm reminded of a adage, and I won't use the vernacular, but, you know, fool me once, shame on me, fool me twice, shame on you, all right? How do we enforce this is my question. It goes back to what Ernie had said, right? We have the 39, almost 40,000, but I have no faith that Mr. Blystone is going to send us a check for $65,000. So my question, Mr. Richter, is how is this then enforced? And that basically goes to my question initially about the agreement just going to court now, because I believe, based on the evidence, particularly what Mr. Knight asked and what Mr. Brown responded, that it would be difficult for a judge not to agree on the clear intent of that language. So that's why I asked that question. But it's really about how do we enforce it if it's not through a court of law.
That would be the manner in which we would have to go, I think, to enforce it, because we would have to go to presumably the Franklin County Court of Common Pleas and move to have the agreement enforced. That's, just kind of a gut reaction as much as anything.
And it still goes, like it's not original, can't we just do that now? So we'll levy a fine, say we levy a fine against Mr. Blackstone. He doesn't pay it. Okay, so what's our next step? So as opposed to taking the agreement now to the court, I guess it would go to the Court of Common Pleas, is it correct? Where it would go?
I think so.
And say there's a violation of the agreement, we're owed 65 based on this evidence. It's clear. I mean, I don't know how anybody can look at that evidence and not particularly give Mr. Knight asked about the net proceeds and the response from Mr. Blystone's attorney.
That is certainly one of the possibilities that we have available to us. If that's what the commission decides to do, I could certainly be in touch with the Attorney General's office in an effort to move this thing forward in that regard.
So the Attorney General would take that.
Yeah, I mean, even the commission, even though I am actually, I am your attorney and the attorney for the commission, as I fit here, once things go outside of the commission, let's to a court of law, then the Attorney General's office would handle legal responsibilities for the commission.
So could I ask Mr. Katz to comment on that? Would that be all right?
I don't know that it can, but you're welcome.
Well, no, but I mean, just his thoughts about where that goes. The Secretary of State is all about this.
So I haven't heard of the procedure before where you would send it to a court of common pleas. The agreement that exists right now, I believe you would just be reconsidering your findings and restating the findings are $105,000 minus the amounts already owed, plus the amount from Delaware County. In the future, you paid within a certain date. And then if that's not done, then Mr. Richard works with the Attorney General's office to collect the funds. Ideally, we would not back burner it like some of your other ones. This is an individual with property in the state that they would be able to collect upon if the party didn't pay their outstanding fines.
And then Mr. Richter, is the time certain when those fees are paid? Or can we say that in the motion?
Well, I was going to say, I would strongly encourage us doing that in the motion.
Okay.
Yes. In terms of whatever we end up doing here today. Certainly there was the 30-day period that was laid out in the original agreement that has come and passed with what was done. So nothing has been subsequently. So I think we could, we should establish some sort of a time frame in which we expect compliance in whatever manner possible, whether part of it is some of the monies that are currently being held in trust by Mr. Brown or whatever else that makes up the total amount that has been stated as what the commission will receive. And put a time frame out there in terms of when we should receive it, whether you want to say 15 days, 30 days or whatever. And if there isn't compliance at that point, then I'm more than willing to reach out to the Attorney General's office and have them proceed as appropriate.
Thank you.
Mr. Brown, did you want to say something? You had stood up.
I disagree with your statement that a judge can construe this as anything but a promise to pay $105,000. But I've already made that argument. So I also know that, we can also just make an agreement, pay the amount that you want. And I know your reaction, well, I don't trust the guy, but you would have more leverage if you had a contract for the specific amount that you want. So we'd be willing to talk to you about negotiating an amount.
Isn't that what we have currently?
I don't agree with you that it's clear that you're at $105,000.
Well, I understand. I mean, made the argument that you stated in the videos.
Yeah, we can make an explicit agreement for the amount. No, I didn't say just that in the agreement. I also stated in the video that I didn't know how much was in the bank account. So if we go to court, my filings are going to say, you knew, I didn't know the exact amount. That was my best guess. But I also did not speak the way I should have in terms of Mr. Knight's question. And I apologize for that. You know, I said that, that I think that's what I'm trying to say, but I'm just saying, if you want to negotiate an actual explicit agreement, I'd be open to talking to you about that.
Other than, I'm speaking to my fellow commissioners here, other than the issue concerning the returning the $9,000, I think that, whatever the amount is, what are the other concerns regarding vacating motion and setting for hearing again? What are other hesitancies in doing that?
My hesitancies are, one of the few things today that I agree with Mr. Brown on is that with between the depositions, all we've heard, we're not going to learn anything new from those hearings. We're just going to spend 1, 2, 3 days, hearing a lot of, kind of dark back and forth, and really come away with, wasted time on behalf of the taxpayers of the state of Ohio. I just don't see that affording anything. I understand if we're looking towards referring to criminal prosecution, it needs to happen for all reasons stated. But I mean, just determining fines and whatnot, I just don't see what we learned that changes anything.
Just to answer the question. So, Mr. Knight, you're saying that in order to refer for criminal prosecution, you think that it would be more of a waste of time to go through a full hearing?
Unless if we're thinking about criminal prosecution, and I defer to Mr. Richter and Mr. Harris's expertise for the, to create a set of facts to allow for that, that is required. Taking that aside, right, if we're just looking at fines and fine reinforcement, I don't think it's a valuable use of time vis-a-vis what we will learn from what we've already learned.
But no objection if the majority of the commission wants to go forth with referring it for criminal prosecution.
None whatsoever.
Okay.
Well, as long as you understand that the precursor for being able to do that is to have the hearing.
Mm-hmm.
Okay, and that's what maybe I was getting at. Even when he says, take it off, if you take that off the table, you can't take that off the table because you have to have the hearing to have that as in the range of possibilities of things that you could do.
Understand.
And yeah,
I
just wanted to have that point put out there
I get
of
it.
what the objections would be.
I-
It seemed like we were starting to creep toward the resolution.
Again, I almost, again, there's a lot of pros and cons here. And, I'm not an attorney, but I stated a Holiday Inn Express last night. So,
Could you highlight that in the
Yeah.
minutes?
We've got to have the hearing for the evidentiary record referred to prosecution. The prosecutor, right, may or may not take the case. And, then you go to trial and there may or may not be, criminal repercussions at the end. And, oh, by the way, the 39,000 and change has been returned to Mr. Blystone. I almost, when I think about the road to the, being a criminal indictment, I guess it was probably the wrong term, whatever the term is. I mean, I will steer on the side of, and make sure that what we have, the 39,000 is not, because that's in the bank.
To that point, Chair Kaufman and Director, has that check been actually deposited in cash? So, okay, so there's no stop payment if there were three. Okay.
And it's cleared. It's cleared as well.
We haven't gotten notice in hand. How about that?
Okay.
That's an answer. So, I mean, that's been February 1 or 2nd, I think. So.
Well, in this modern day, you can step out and
Find out.
lie.
Yeah.
I like the idea he can run down there.
Yeah.
Do it.
That was one of the checks that was in the materials that were presented to us, but I think it was cleared. So, yes, we're good in that regard. I guess, I'll restate maybe, I appreciate all that's been said. I think this is a good session for the commission to go through the process here, but maybe the best recommendation I can make at this point is to restate that maybe the commission needs to restate its expectation that it would receive $100,000, no less than $100,000, as stated during the presentation to the commission, in that, there are certainly sources of funds available to Mr. Blystone to make that come into fruition, whether it's the monies that are out there in Mr. Brown's trust account or from some other source, and that amount should be paid to the commission by March 31, 2023, in an effort to try and move this result forward. Kind of kicks it down the road a little bit, but March 24th, whatever, it's about a month from today.
Let me raise one other point real quick. Sorry, John.
No, that's fine. Go ahead. I was just throwing that out there to
That's,
have
what,
framework.
the money also is not the only aspects of the settlement. You also have the aspect of Mr. Blystone agreeing not to run for office X number of years and some other factors too.
Correct.
So, that's a factor in here as well that still remains, under enforcement. So if we vacate, so if we do vacate, that goes away.
That goes away as well.
Or at least for the time being, it goes away as well. Just wanted to keep that
That's a good point.
top of mind as well, just on that.
This is the only contractual obligation that exists currently
Correct.
between all the parties. What exists now that could be put through?
So,
Right.
so I guess my question is this. And I might be out left field. So we have the payment to make the number whole, due by March 31st. If that doesn't happen, do we have recourse other than to give it to the AG, or can we stipulate if it's not paid and made whole, then we will take XYZ step?
Such as, only because what are the other?
I mean, to refer for prosecution, or, I mean, if.
Except for a full hearing.
Not in the
Purple
same
here,
position
yeah.
then as we are exactly right now, or we
Yeah,
still
to a
have,
degree, yeah.
yeah, so
I
we
guess
still
so.
have to.
Yes,
change.
you're amending the agreement then, right?
Mhm.
And you need the other parties here. That
Okay.
whole-
Yeah.
If I may speak to that, I believe the other council was contacted during a recess.
Yeah.
It's amenable to our positions.
Yes, we did contact Mr. Hartman. He had a doctor's appointment that could not be changed. He's as stated, will go concur with this resolution.
He'll do what? I'm sorry.
He will concur with this resolution.
Resolution being
That's
just
right.
stated one more time.
Okay, that the additional, whether 60,000 or 65,000, whatever the amount is to be paid within 30 days or 30-some days, whatever March 31st is.
Essentially an extension of the existing deadline.
Yes.
Thank you.
Madam Chair, on that note, I guess I just don't understand why we're giving them another whole 30 days when they haven't complied. I would make it much shorter, 2 weeks at the max.
I was gonna say, I just put that date
Yeah.
out So I'm understood.
Yeah, because we've given them 30 initially and look what we got.
Chair Kaufman, the only other question I would have is what happens to that retained amount that's in the Delaware County Court if it's not utilized for those fees? Does that, and say this 100,000 is met, what happens to that financial portion?
That stays the same, that comes back to us.
It's not part of the,
Whatever's not utilized there comes back to the commission. That's a separate part of the agreement.
that's not part of the approximate 105, correct? Okay, there's
Correct.
two separate,
Yeah,
okay,
correct.
thank you. Yeah,
Correct.
that's great.
And that's in the control of the court, the Delaware clerk, or the Delaware court system, I guess I should say. But March 10th would be, a Friday, 2 weeks out.
Madam Chair, question either. If we were to vacate, as opposed to returning the 39 and change, can it be put into an escrow of some sort in anticipation of the future determination and returned that resolution?
As an administrative agency, our authority and our abilities are relatively limited. It's all statutory out there. And as we talked about earlier, the commission statutes say you've got to do one or the other. Good cause, impose a fine, refer for prosecution. Those are the, and it's not a you can do them together. And we have those funds. There isn't any, that's not mentioned anywhere, so I don't know whether we can do that or not. My gut says we can't, only because of our, the limitations that are placed on an administrative agency, such as this commission. And so if we wanted to do something like refer for prosecution, we can't have those monies accepted as a fine amount. I think as considering the mutual nature of what we've done here at this point. Could we go back and again bifurcate a finding? I guess potentially, but I'm hesitant to say that only because it's not something that we've ever done before in this kind of a context where you have an agreement and the agreement's been partially completed with the payment that we've received so far. I'm just not sure because this is new and different, distinct than anything we've gone through before.
Thank you.
Madam Chair. Mr. Richter, in the Elkins case, the mayor of Cleveland Heights or whatever that community was.
Whatever it was.
After he entered a plea of guilty, did we receive any kind of money as the Elections Commission? Did we receive any money? I know there were fines assessed, but
We did receive those fine payments from the.
how much was that? Approximately.
I have to go back and look specifically, but I want to think it was like, was it $1,000 or something like that on the committee and about 100 on the treasurer or something like that.
Okay.
And those amounts were received. Those were received prior to the full resolution when he was actually, as the prosecution was completed.
Okay. Thank you.
Other comments or questions?
So we're going to need to take action, official action by way of a motion.
I think in some manner or form, I think we should.
Yeah.
Only because.
I think so too, for the record.
Yeah, I mean, not just for the record, but keep the process moving forward.
Well, I'm also thinking if there's ever any litigation in this case, we may want to have.
Exactly. So, yeah, I mean, I would just, again, I think restate that the commission has an expectation to receive. I'm going to say 100,000 only because that's what was presented as a part of Mr. Brown's comments on January 5th. The commission has an expectation to receive $100,000 in total. that it has not received that amount. It has only received a partial amount, a portion of that amount, excuse me. And that the commission has an expectation that the remaining funds will be received by March 10th, 2023. And that at that point, if those funds are not paid at that point, then the commission will be prepared to seek enforcement of the agreement as appropriate. You got a quizzical look on your face. Okay.
It's a motion. Or it's phrasing the motion for someone else to make.
Madam Chair.
Yes.
So, Phil, I know you're using the $100,000, so I just like to be a little more specific. You have the 100,000. We've received $39,681.76. I think the motion should state that, say a total of 100, but I think it has to specifically say $60,000, $318.24 is what is owed to the commission.
Okay.
Just
Makes sense.
And then all other stipulations in the agreement
Remain.
remain, correct?
Spend a couple days in law school.
Hey, serving in that legislature.
Okay. So we've heard Mr. Richter's recommendation. Would someone like to eloquently put it in motion form? Like specific language, or you feel like you had?
I'm willing to,
Yes, I
I'm
mean, you
willing
can
to
do it.
give it a try. That the commission, as stated in the original agreement, and specifically stated in comments made to the commission on January 5th by counsel for the respondent, that the commission would receive no less than $100,000, but that the commission has received only $39,681.76, and that the commission expects to receive $60,318.24 by March 10th, 2023, to comply with the terms of the agreement that the commission entered into with the parties on January 5th. And all other stipulations or all other elements of the agreement remain in full force and effect.
Hearing the recommendation, do we have a motion?
So moved.
Second.
Okay,
Nobody else.
we have a motion on the floor that's been duly seconded. All in favor, please signify by one. I think we should do a roll call.
Yeah.
That's fine. I can do that. Give me a second here. Mr. Beatty.
No.
Mr. Knight.
Aye.
Mr. Kreitz.
Stay.
Ms. Tavares.
Yes.
Mr. Lyle.
Yes.
Ms. Hagan.
Yay.
Chair Kaufman.
Okay.
The motion passes 5-2 with no votes by Mr. Beatty, excuse me, and Mr. Kreitz. Okay.
All right.
Madam Chair, may I ask a question of, I guess, Fire Commission? Is it, I mean, can the commission do what amounts to the equivalent of a censure, like a motion that puts on the record a formal review of the activities that have transpired over the last 30 days in particular?
I mean, I don't know why you couldn't motion to that effect and have it acted upon by the commission. I'm not sure what, what impact it has or what, what legal authority it has. But I mean, over the years, the commission has made motions to compliment members on, lengthy service, those kinds of things. So not that that's exactly the same, but based on what you're talking about, I mean, certainly it is an action by the commission that would be reflected in the minutes.
I would like to move that the commission formally review the actions of Joseph Blystone, the Blystone Campaign Committee, and their counsel for acting in bad faith agreement, and to rebuke Joseph Blystone for communicating unfairly and negatively upon the integrity of this commission publicly.
Okay. we have a motion.
Nice meeting.
That is the motion.
Yeah, we have a motion. So we
Oh, I
have a
thought you said.
No.
Can we have a
No,
motion?
no, we have a motion on the floor. I mean, hold on, we're in the middle kind of something, so I don't. No, so, second on that motion.
I would just like dialogue.
Yes, thank you.
This isn't the first time that I've been offended by somebody, and it's not unusual. I don't agree with statements or slander that are made, but I will likely go present because I believe in free speech. Albeit unfortunate that this was conduct and the acts of what the was characterized. That's my personal feeling. I don't feel strongly enough that something to that extent needs to be established in this moment of heightened emotion personally. But I understand it, and I've just been through it a few times.
I've been through it as well, but, my clear understanding is it continues, right? And it's ongoing. And certainly, post this meeting, I have every expectation it's going to heighten. So, that's my.
Madam Chair, question for our legal counsel. Mr. Richter, in the event that we would pass this, this motion and for whatever reason we would have to proceed to a hearing, is the objectivity of the board thrown into question?
I guess I guess it could certainly be questioned, yes. But I don't know that that would necessarily mean that there was a particular perspective on the outcome of the hearing. I over my years of working with this commission, I think there have been various times, not when there's been a motion like this, but when the commission has been bothered, offended, or whatever have you, by either parties or counsel that have been present before the commission. But I don't feel that that has impacted the way the commission has assessed any evidence presented to it or made a full and complete decision on a case.
Yeah,
That's been the history that I've noticed of this commission.
Yeah, I can understand after all the hearings are conducted, the matters concluded, the board may be considering to take a position like that. I'm concerned for the board, though, in the event this case is concluded and there's litigation to follow and the board is called upon to render a decision, that there may be a question of its objectivity, and I would hate to see that happen.
And I can't say that that wouldn't occur, no. But again, that's this case is these particular cases have led to a number of novel circumstances for the commission, and
Yeah.
that would be another one right there, in terms of, what the potential impact of something like this would be before, on the commission in the future. And I don't know that, I can answer that question at this point.
Okay.
Fairly or equitably. I guess I would, with all due respect to Mr. Knight, I understand and respect where he's coming from. Certainly, everybody has expressed their respective opinions as I would probably encourage the commission not to move forward on this
At this time.
at this time.
And may I speak since I'm subject to this?
I will give you both a chance to speak, but just a
No,
minute.
no, it's not for him.
No, but, I mean, we need to finish this business first. So, we've heard the motion made. Is there a second? Okay. Hearing none. The motion,
Dies for lack of a second.
that's what I see, dies, but dies for lack of second, telling me. So, okay.
I've used that terminology before.
Dead on the floor. So at this time, I'm gonna put it to the commissioners, Mr. Pullins and Mr. Brown have both indicated that they would like to speak again. Do we need to have any more comments from them, or are we okay with where we're at on this?
We're fine.
Okay.
Fine.
Okay, so
Yeah, any
respectfully,
clarification should just be with Mr. Richter at
Yeah.
a later date.
so,
I'm
Any-
available and available.
yeah, so, anything else past what we've already decided will be, a conversation with Mr. Richter, so. Okay, so I think that we have, went through the agenda. Thank you very, very much for your time today. Very much appreciate it.
Thank you.
And then I